Okay, you have seen this a million times in courtroom dramas, right? A key witness is on the stand, the lawyer whips out a document, and bam! Their entire story just completely falls apart. It's always super dramatic, but what are the actual rules? Let's get into it, because what really happens is this fascinating legal dance with some very, very specific steps.
So, here's the setup. On the stand, under oath, a witness says, "The car was blue." But the lawyer is holding a signed statement from this exact same witness where they said, clear as day, "I remember the car being green." It's a total, complete contradiction.
So what happens next? This is the crucial moment. Can the lawyer just stand up and shout, "Aha, you lied"? Well, not quite. The law actually has a very strict playbook for this exact situation, and it's all designed to be fair while still trying to get to the truth.
Right, so there's a formal rulebook for this kind of confrontation. The lawyer can't just spring that green car statement on the witness without following a really specific procedure. This is especially true when the witness isn't even the person who wrote the document.
Here's how it plays out step by step. First, the lawyer has to show the document to the witness. Now, you'd think the grilling starts right here, but nope. The witness doesn't actually have to answer any questions about it, yet. That can only happen after step 3. When the document is tendered, which is just a fancy legal way of saying it's been formally offered and accepted as evidence in the trial.
Okay, but here's where it gets really interesting. What happens if that document, the one with the green car statement, can't legally be used as evidence in the first place? And this happens way more often than you'd think. What can the lawyer do then? The rules here are incredibly specific. If that document is inadmissible, the lawyer's hands are pretty much tied. All they can do is put the document in the witness's hands and ask one simple but very powerful question. Having read this, do you still stand by your testimony? And that's it. They can't cross-examine them on what's inside it. Nothing.
So, you're probably wondering, why would it be inadmissible? Well, a really common reason is something called hearsay. Hearsay is basically a second-hand statement. It's something that was said or written outside of court, and now someone is trying to use it in court to prove a fact. And as you can imagine, the legal system is usually very, very cautious about that.
All right, so we've got the basic procedure down. But, just like with any set of rules, there are always exceptions and weird situations that make things a lot more complicated. Let's look at how things can change, because it turns out that who the witness is and what kind of evidence you're talking about, well, that can change everything.
It makes a huge difference who the witness is. If they're a party witness, meaning they're the actual plaintiff or defendant in the lawsuit, they can be questioned about the document's contents even if they didn't write it. But for a non-party witness, just a bystander who saw something, the rules are way stricter. You can't just grill them on a document they had nothing to do with.
The type of evidence you have also really matters. What if that prior statement wasn't written down, but it was on a tape recording? In a trial with only a judge, the lawyer might be allowed to play it for the witness. But in front of a jury, the source material says that would almost certainly be forbidden. A recording can be so powerful, so persuasive, that there's a huge risk it could unfairly prejudice the jury no matter what a judge tells them.
So we know how to bring up the contradiction. But this all leads us to the biggest, most important question of all. What is that prior statement actually worth in the eyes of the law?
Let's go back to our example. Does the witness's old statement that the car was green now become actual proof that the car was green? Or is it only useful to show that, hey, maybe this witness isn't the most reliable person? This is really the core of the whole issue.
And the answer depends massively on whether we're talking about a civil case or a criminal case. In a civil case, say a lawsuit over money, that prior statement can often be used as actual evidence. It can be used to argue the car was in fact green. But in a criminal case, it is way, way more complicated. The court has to carefully weigh how valuable the statement is against the very real risk that it could unfairly turn the jury against the person on trial.
And that's because someone's freedom is on the line. The judge's role becomes absolutely critical. If the statement is allowed in, the judge has to give the jury extremely careful, extremely precise instructions on how to think about it. They can't just say, here's another piece of the puzzle. They have to guide the jury on exactly how much weight, if any, they should give that statement.
In fact, this quote from the source material really sums up the high stakes perfectly. It says that a conviction is not safe if the only piece of evidence holding it up is a prior statement that the witness themselves is now contradicting under oath in open court. That is a massive protection for the accused.
See, all these little details, all these procedures, they're not just about lawyers playing gotcha. They really get to the heart of how our legal system tries to balance this incredibly difficult search for the truth with the fundamental need for fairness.
So let's just quickly recap the big takeaways here. First, there was a formal, step-by-step process for using a prior statement against a witness. Second, the rules are totally different depending on whether the witness is part of the lawsuit or just a bystander. Third, special kinds of evidence, like a tape recording, have their own unique rules. Fourth, how that statement can be used as actual proof is much stronger in civil cases than in criminal ones. And finally, and this is the big one, in a criminal trial, you generally can't convict someone based only on a statement that they now take back under oath.
And that really leaves us with a final, pretty deep question to think about. This whole system is built to carefully manage the fallout when a witness changes their story. So in the end, in that difficult search for what really happened, is a contradicted statement, with all of its problems and complexities, better than having no statement at all?